to today's Savant Live webinar. Thank you for joining us. Today we are discussing estate planning essentials. I am Andy Welp, Managing Partner of Savant Legal, and joining me is Senior Director of Wealth Transfer, Mike Cyrs. Thanks for joining us, Mike.
Great to be here, Andy.
So today, Mike, we're going to be covering estate planning for the recently retired. Okay, we'll talk through some ways to minimize tax through proper estate planning, some common estate plan mistakes that we end up seeing in our practice and viewing documents, and how advanced medical directives work, some charitable giving and legacy planning topics, and then we'll end with some Q&A if we have some time. So with that, Mike, I'll turn it over to you to talk a little bit about estate planning for the recently retired.
Great. Welcome, everybody. It's great to have you and to here today with us and to talk about estate planning. And we've got some, very specific things I think that fit this particular demographic when it comes to estate planning. But Andy and I've got over 31 years dealing with estate plans, drafting for 21 years, and now in-house with Savant on the inside doing reviews for clients. And I can tell you, it's super important to do estate planning well. Not only can it alleviate a significant amount of estate tax burden or income tax burden more appropriately today, it can avoid family conflict. It can create structures for efficient administration of your affairs. And so estate planning is really something that you want to make a priority for your family. It's a gift to your family to do well and to spend some time in this arena. Now, when it comes to those who are about to retire or recently have retired, what makes this an appropriate time to take maybe a bit of a different look at it or a stronger look at it from an estate planning perspective? And there are really a couple of things going on at this point in time. One, you have some time to do it. So hopefully, if you make this a priority, it's a good point in time to step off the train a little bit and say, I want to get these things in order and make sure everything, all my I's are dotted and T's are crossed. I can tell you that if you do this and you go through this exercise, it's a good idea to do it because you'll feel better about your affairs. You'll have everything kind of buttoned up. And you're going to have to do it anyway. There's going to be work to be done. Life can throw you curves with respect to incapacity, of course, or a death at some point in time. It's going to need to be done. So you really want to take advantage of the opportunity to get in front of that. And we often get asked, what is the timetable once you get your affairs in order as lawyers or legal counsel? And the rule of thumb is usually every 5 years, but it's really changing circumstances. I think it tends to be a good idea to take a look at your estate plan in depth with counsel on about a 3-year timetable every 3 years. Certainly, I've had complex estates where I was reviewing the plans and we were updating them every year. So even on a stronger timetable than that. With respect to retirees, there are things that are going on that are gonna upset the estate plan naturally. So, for example, you may be doing changes, rollovers with respect to employee benefit plans, 401ks, 403bs, et cetera, into an IRA format. You're going to be choosing beneficiary designations. And as we're going to talk a little bit about in the future, you're going to have to choose primary and secondary beneficiary designations. And this is a place where you can get tripped up if you're not paying attention. So money is in motion, it's moving, accounts are moving. That's why it's important to take a look at your estate plan at this juncture in life. You might be acquiring new real estate. You might be purchasing a condo or a retirement home. Again, the title of those assets is going to be instrumental so that the estate plan works as designed. Should it be held in some form of joint tenancy with a surviving spouse to obtain the benefits of asset protection? Should it be titled to a trust to avoid probate? These are all types of considerations that are super important and at this juncture for the design of an estate plan. So as we move forward, what are the primary elements of an estate plan that everybody needs? And I like to look at this, if you can, think about it in the kind of a timeline. And on the left of the timeline, you're perfectly healthy and able to get your affairs in order. And then you sort of progress down the timeline to the right, where sometimes estate planning professionals say the estate plan matures, so to speak, and there's an administration period. So on the left side of the timeline, now's the time. You're able to think clearly, grab all of your documentation, get it in one place, organize it. put it in a safe deposit box or a safe at home or a safe place. The more information that is arranged and ordered for administration later on, the better off that you're going to be. In there, you can make arrangements, pre-arrangements for funeral or burial, cremation, etc. You can write letters of instruction to family members, to fiduciaries that may be taking over, potentially later on. So you can document passwords and usernames for digital assets. The more information you get together on that far end of the timeline and consolidate it and organize it for somebody to administer your affairs, the better off you're going to be. As you move further down the timeline, you're going to want a set of documents called powers of attorney, documents where you name someone to make decisions for you if you can't make decisions for yourself. We're going to talk about some tips later on in this area, again, specifically for those that are recently retired or about to retire as well. Super important because they will avoid having to have this guardianship appointed for you if you become disabled. So again, moving down the timeline from perfectly able to make decisions for yourself to the point where you can't make decisions, you'll want those powers of attorney in place. The next set of documents often is a living will declaration. And that's a specific legal document that says that if you have a terminal disease, condition, or illness, death is imminent. And 3, a physician certifies that nothing can be done for you other than that which will prolong death, that you wish to die naturally. So again, important element of the estate plan. It avoids the agent from having to make end-of-life decisions. Some agents are empowered to do that under some powers of statutory forms, powers of attorney for healthcare, but the living will is a nice adjunct to that to make it such that the family members or the agents don't have to make that end-of-life decision. And then, of course, you get into the will or the trust and the trust administration period, and this is where the rubber hits the road, and we want to make sure all of your affairs are up to date at all points in time. What are some of the goals of estate planning? Certainly, probate avoidance, no matter what jurisdiction you're in, is a good idea. This is the ability to use a revocable trust that's essentially self-empowering and gives authority to a successor trustee, either another family member or perhaps a corporate trustee, automatic authority to take care of your affairs. You want to have a structure for the efficient administration of assets. You want to look at all of the assets that are out there, how they're titled, how the beneficiaries are lined up. And again, as we're going to show in a few minutes here, not only the primary beneficiary designation on these assets, but it's critical that the secondary beneficiary on these assets also be aligned appropriately. Protecting assets from creditors is always at the forefront of what we do. This can most predominantly take place with respect to children or grandchildren and the delay of distribution until they get to be a more responsible age, or perhaps their marriages get more settled, etc., or for a surviving spouse, just to plan for a possible remarriage. And again, we're going to kind of start out taking a look at estate taxes and income taxes and how we want to make sure we're doing the right things there. So, all right, let's talk about Andy. I'm going to just kick it back to you because I think there's no greater area that we find in estate planning that is worthy of attention to detail is the designation of your beneficiaries on various assets. We're seeing an increasing significant portion of one's assets being controlled by beneficiary designation through IRAs, 401ks, 403bs, et cetera, annuities, life insurance. And it is almost a complete correlation that we find a disengagement between the design of the estate plan by the attorney and the primary and secondary beneficiary designations that are out there. So Andy, why don't you just take it from here for just a couple of minutes and talk about that?
Yeah, sure, Mike. Thanks. So talking through beneficiary designations, when I meet with clients, I will always tell them that estate planning is really 2 parts. Okay, as Mike said earlier, part 1's really getting your documents into place. Okay, so creating the plan, sitting down with the attorney and going through it. Okay, part 2, which a lot of people miss and is quite frankly just as important as getting your documents put into place, is making sure that all the assets that we have flow through the documents that we just created. And as Mike said, retirement accounts are becoming a larger and larger portion of people's total estate plan. So it really makes a lot of sense to cue in pay particular attention to what those beneficiary designations can look like on those retirement assets. So let's talk just briefly about different types of retirement assets and the laws governing them. So if we're talking about 401k types of accounts, okay, there's actually a federal law out there that says my surviving spouse has a right to be the beneficiary on those types of accounts, unless they actually waive that in writing. Okay, so if we're trying to do some more advanced planning, or maybe we want to include the kids or grandkids on those assets, when you go to do that beneficiary designation, your spouse is actually going to have to sign off on that. Now, if we start looking at other types of retirement vehicles, such as IRAs and Roth IRAs, they are not governed by that similar federal law. Okay, so when you're doing a rollover from your 401k to your IRA, the surviving spouse isn't going to have the same rights under that document. Okay, now, when a surviving spouse inherits a IRA, okay, there's some special rules around what the tax deferral for that can look like. Okay, the Secure Act came through in 2019 and kind of upended how tax deferral works for folks. It used to be whoever inherited a retirement account like an IRA, they got to use their expected lifetime to take out what are called required minimum distributions. Okay, the IRS doesn't allow you to keep your tax deferred money deferred forever. They make sure that you have to start taking little chunks out over time. Well, when the Secure Act came through, it used to be almost everybody got to use their expected lifetime. Now most people are set into a 10-year time frame that they can do that. Big exception remains the surviving spouse. So what the surviving spouse has the ability to do is if they inherit say that my wife inherits my IRA, she has the ability to do what's called a spousal rollover. Essentially, she's taking my IRA, she has the ability to put it into her own IRA, and then at that point, she doesn't have to start taking those required minimum distributions until she reaches the age where it would be required for herself personally. At this point, that is age 73, and it starts to ratchet up eventually to, I think, 10 years from now, it's going to be set at 75 years where you start taking those amounts out. Okay, because of this tax deferral flexibility, retirement accounts, most of the time we are recommending that you want to name your spouse as your primary beneficiary on them, okay, because of that tax benefit. Your contingent beneficiary, a lot of times if you don't have a plan put into place, it's going to be your kids. Okay? But now when we end up getting a plan put into place, our plan might have holdback provisions for young beneficiaries, be it our children or be it potentially grandchildren if something happens to our kids. But if we don't run the contingent beneficiary through our estate plan by naming, let's say, our trust as the contingent, we lose all kind of the holdback provisions that we created within our document. So you can see having our beneficiary designations match up with the plan that we created is really important. So after we put the plan into place, typically what you're seeing is now we are recommending continue to name your spouse as your primary beneficiary, but now you might want to run your contingent beneficiary through your trust to pick up the holdback provisions that we created for those young kids. Anything to add on beneficiary designations, Mike, or should we kick it into minimizing taxes?
Just a couple of things on those beneficiary designations. It's just super important. I want to make sure the audience understands that generally people will name, in many cases, the spouse as the primary beneficiary, and then they'll name often children as secondary beneficiary, often using the legal term per stirpes. And as you said, Andy, what that means is those will be outright distributions. They're going to, no matter what age those beneficiaries are, if a child predeceases and a young grandchild, for example, steps up, they could receive a significant distribution at a very young age, 18, 20, perhaps even earlier. There would be a minor's account that would probably be established if they were a minor, but nonetheless, they would get it at potentially age 18. And so, you're into a situation where you want to name the trust as the secondary or contingent beneficiary, because in the trust, there are all these provisions which, oftentimes will withhold, they'll establish a timetable for allowing unfettered rights to those assets. It might be a third at age 30 and a third at age 35 and the balance at age 40 or some delay. So it's super important to align those beneficiary designations into those subtrusts. And we'll have a slide that will show that, so that the trust, which is slowing down the distributions, is garnered through the primary assets of the estate plan rather than the direct naming of beneficiaries. And so it's critical that those things be lined up. Now, here's an example where you talk about, looking at the estate plan as well. I think it's worth pointing out, prior to the Secure Act, to get a minimum distribution period that was equal to the age of the beneficiary, lawyers would draft what were called conduit provisions into the trusts. And what a conduit provision is, kind of like a conduit, it's a pipeline, of the whatever RMD comes out directly to the named beneficiary. And where that worked prior to Secure Act, when we had a very, we were potentially going to have a 20 or 25-year-old grandchild if a child predeceased. And so if we had a 25-year-old, we would have a 60-year life expectancy. The conduit would flush out 1/60th. Now with Secure Act, it's a 10-year distribution. So we're flushing through within a very short period of time all of the RMDs, and of course the entire account under the new Secure Act provisions within 10 years. So what this means is the lawyer has to pay special attention. We'll show this in an example here in just a little bit. You might want conduit provisions as to a spouse's trust, but you might want them in there for a child's trust, depending on the age of the children. If they're old enough and we're not concerned about a potential divorce or something like that from an estate asset protection standpoint, but not for a grandchild's trust. And so many times these documents that we see, they'll just have conduit provisions in them across the board. They won't differentiate between the different levels of estate planning. And you can end up, if you have those provisions in there, entirely undermining the estate plan, the integrity of the estate plan. So it's not only a function of who's the beneficiary, trust or individuals as the contingent, but it's also looking at that instrument to see if conduit provisions are there, and were probably placed there prior to December of 2019. And here we are in December of 2023, 4 years later, and they will entirely undermine and undo that estate plan potentially as to, flushing through distributions to grandkids. So.
Yeah, so when you, back a few slides ago, when we said that one of the times that you should be looking at your estate plan is major tax law change. Secure Act was certainly one of those times where Congress came through with a rule and it kind of upended what the plan actually looked like, where a perfect plan that existed for you pre-2019 now is doing the complete opposite of what you wanted via the conduit provisions. So moving on to minimizing taxes through proper estate planning, Mike.
All right, great. Thanks, Andy. So, really two types of taxes here. So the first is the estate tax side of things. All taxes aren't equal, of course, and there's also the income tax side of things. So let's start on the estate tax side of things and look at the changes over time. The good news here is we are at a historical all-time high with respect to the exemption from federal estate tax for most U.S. citizens. So you can see from this chart here, that we were at a $600,000 exemption from 1987, into the 2000s, 2002. A slow climb for there. We're at 12.92 million right now. The exemption for next year is inflation adjusted to $13.61 million, and that's per person. So a couple, with $24 million of wealth is going to be exempt from federal estate tax currently, okay, or a single individual with 13.6 million next year. So a huge benefit, but there's a big deal. There's a big change coming down the pike, and that is that the doubling of these exemption equivalents on the federal side is scheduled to expire at the end of 2025. It will be cut in half. And the inflation adjustment amount that's estimated then for the exemption for federal estate tax will drop down to about $7 million. So that's something to keep on the horizon. We're going to need to keep watching that. Some states still have a state estate tax, okay? And here you also need to be very careful when you're looking at your documents and assessing them, especially for retirees, because it depends where you place those assets. For some states that have a state estate tax, the credit is not portable from one spouse to another, and it's much lower. For example, in Illinois, it's a $4 million per person exemption, not portable from one spouse to another. So if you leave all of your assets, you name the spouse as primary beneficiary on IRAs, you have a number of assets that are going directly, either joint tenancy or through a trust to a surviving spouse. If the survivor has an amount of assets over the exemption equivalent, you could have $300,000, $400,000, $500,000 very quickly of state estate tax, merely because you didn't pay attention to the titling of the asset, to make sure, it's not just a simple account change. And it can be that easy. A simple re-registration of account or a simple a tweak of a beneficiary could end up potentially saving, $400,000 or $500,000 of state estate tax. So we got to keep an eye on this estate tax going forward. Kind of the big, I want to comment just briefly here. Estate tax, even once the exemption threshold drops on the federal side, is hopefully people are going to be able to work around it, or they're beneath that estate tax. The big side is going to be the income tax side. And before we flip to the next slide, a couple of numbers. The deficit for 2022, the federal U.S. Treasury deficit was 1.4 trillion. This year, it's 1.7 trillion. It's up 375 billion just since the CBO's last estimate, which was in May of this year. So I just received a tax alert. And so the need for revenue to the U.S. Treasury is growing. And I would just caution, I think we're going to need to keep an eye on basis adjustments from a legislative perspective, capital gains taxes, and other ways to raise revenue besides the federal estate tax code. And that could impact a lot of those in the audience right now, because currently we receive a step up in basis at death in assets to fair market value, which gives you less capital gains tax as a beneficiary when you sell those assets. The American Families Plan proposed a credit for basis adjustment similar to the estate tax credit here, and then you could apply that to certain assets, and then propose taking the highest capital gains rate of 20% and leveling it with the income tax, the federal income tax rates, which would more than double it when you add the net investment income tax to that as well. If that happens, a lot of people who might take comfort that they're below the federal estate tax thresholds might find that without proper planning, the U.S. Treasury is sort of plugging that hole, additional revenue to plug deficits through higher capital gains tax, loss of step up in basis, and the application of unrealized gains to a lot more people than otherwise would be there.
One thing I would add, Mike, on
Sure.
State level estate tax, just because we are talking to people going into that retirement, it would probably be helpful to know that the Sunshine Belt states, as I like to call them, all do not have state level estate tax. So I believe the southernmost state that has a state level estate tax is Kentucky. All those Sunshine states, they're trying to get the retirees to come down by not having that state level estate tax put in place.
That's great, Andy, too. And also for those, retirees that are heading, if you're in a community property jurisdiction, so for example, Wisconsin, and you're heading to, for example, Florida, residency in Florida, you want to be able to maintain your community property status with your property in a trust, even when you drift into that non-community property state, because you'll get a full step up in basis in all of the assets at the first death for your community property that you have. So these are types of planning paradigms as well. If you're making those changes and you're gravitating from a community property state, perhaps to the south where it's not a community property state, super important to preserve that marital or community property so you get that full step up in basis at the first death, which allows a surviving spouse then to change the complexion of those assets without incurring a capital gains tax at that point in time. So, okay, so here's a diagram. We use these diagrams routinely in our planning. You can see all of the assets are pinpointed there. Some of them are in a joint trust. Some of them on the right there are passing by beneficiary designation. And again, we want to identify primary beneficiary and secondary beneficiary. You can see at the first level, then you can see a yellow family trust or a traditional credit shelter trust from an estate planning perspective. Sometimes we also call that a bypass trust. And then we see the trust for the next generation, in orange there, the children's trust or the grandchildren's trust. And the important thing here again is to look at the funding of these trusts. So let's take a look at the next slide. So at death of one spouse, you can see, lying through it, the living trust there, the primary revocable trust for this couple goes away. The assets are then going to drop down, those that are owned by that trust, and it would be only those assets owned by that trust, right? They have to be titled to that trust. And the funding formula here is a little bit complicated. We have the yellow trust that's free, the family trust of federal estate tax because the exemption is so high. We have a marital trust too, which is partially yellow, partially red, and that's because for this particular example, we have a situation where there's going to be the application of some state estate tax without federal tax because the state threshold is lower than the federal threshold. And then we have a pure marital trust where it's going to be subject to both state estate tax later on and federal estate tax. So in this case, though, we can put $4 million into that yellow family trust entirely free of federal and state estate tax. The surviving spouse can be the trustee of that trust, okay? And so we would drop those $1.9 million in assets there, but close to $2 million, I guess $2 million. The other assets are passing by beneficiary, and since we have the spouse surviving, that's $2.1 million in assets directly to the survivor. Now we talk about taxes and planning, so this is super important. Here we have some nice asset protection going on. We have $2 million that this couple knows is going to go to the hypothetical two children here. The spouse can use it if they need it. They're the trustee. It's protected from creditors. It's protected from remarriage, but it is there for their use. And they know it's going to go down to the children later on with some flexibility. And then we can have the sub-trusts built in. The other assets are going directly to the surviving spouse by beneficiary. Those assets could become part of a new marital estate. There's no asset protection there whatsoever, but we've got a nice balance and mix of assets. Now we could change that balance if we wanted to. So for example, on that IRA there with 900,000, if we wanted to, we could name the beneficiary of that account to the family trust. Now, if we did that, we would switch from a minimum distribution period of a spousal rollover, which would be the uniform table for required minimum distributions, which would be for a 72-year-old about 1/24 or 25th in the year after the required beginning date is achieved, to the single life table, which you would use under the family trust. You'd still get a strong income tax deferral, so it would change from about 1/25th to about 1/15th, okay, of the account would be the RMD. So still significant tax deferral, but you'd be funneling some of those assets into that family trust, which would give you asset protection, remarriage protection, protection that those assets are going to stay within the family. So we've got, you can see in this example, hopefully it's super important as to the mix on these beneficiary designations. Now, sometimes they won't have a nice mix like this where there's 2.1 million on the IRA side and $2 million nicely tucked away. They might just have 500,000 a piece of real estate, for example, everything else in an IRA form. And in that case, again, you're going to want to use those conduit provisions inside that family trust so that you get this nice long deferral of income tax during the surviving spouse's over life. Not as good as the single life or the uniform life table. You'll get the single life table, but strong enough that you're going to be able to have that asset protection assurance plus a significant deferral to accomplish both of those objectives. Now, with respect to the GST trust, that stands for generation skipping down for the children. Here's where, if you name the trust as beneficiary, secondary benefit, you could name the spouse as primary, which would allow a spousal rollover. If the spouse disclaims, they can bounce those assets into the family trust if they survive. If not, it goes to the children. If the children's trust is an outright distribution, there would be a 10-year RMD period there, and you'd be fine with that. and you could use conduit provisions, as I mentioned earlier there. But with respect to the situation, if it happened that a child predeceased and a grandchild stepped up, therefore, to take the predeceased child's share, you wouldn't want the conduit there because it would flush those distributions directly out to those beneficiaries. So it gets a little bit dicey. This is where you kind of have to work through your diagram, think it through, look at your assets, look at the trust instrument, look at the language. And again, retirement is the perfect time to do that, because this is an opportunity. Are things titled correctly? Are the beneficiaries lined up, both primary and secondary? Because you want to give yourself optionality. And the income tax side of things can be as important as the estate tax. The estate tax side, as I said, the thresholds are pretty high, but the income tax side of things is where I think that we can have a significant benefit from paying close attention and having top-notch advisors working with you on these affairs. So anything to add there, Andy, or otherwise we can.
Yeah, the other reason that I like the idea of having surviving spouse primary trust as a contingent is if you are residing in a state that has a state level estate tax that's significantly lower, and you do have that lopsided arrangement where maybe you have home and you have a huge chunk in retirement assets, surviving spouse might want to disclaim some portion of the retirement assets into that credit shelter family trust from an estate tax purpose for state level estate tax to get that out of the estate. But that's the only piece that I would end up adding. So now we're going to cover some common estate planning mistakes that we tend to see. First one, clarity, write it down. So, and this doesn't just necessarily have to cover the legal documents that we have. So as Mike talked a little bit earlier, there's a whole, most of the time when someone passes away, whoever's wrapping up the estate for them, there's a great chance that that's the first time that they've had to do that. And there's so much pre-work that you can be done that really helps them out once they have to step up into that role. And again, it's not just the legal documents. So think about passwords to online accounts. Are there credit cards that need to be turned off? Are there memberships that need to be canceled? All these things, it used to be that, the bill would come from whatever place you had the membership into your mailbox. Well, now we're at the point where everything's kind of flowing into our emails. And so is your child going to know what they have to do at that point, which is another reason why powers of attorney are so important in making sure that we have the ability to access those digital repositories. Again, big one, we've already kind of hit on this, beneficiary misalignment. Remember, your trust can say, give everything to Andy Welp. If your beneficiary designation says, give everything to Mike Cyrs, it doesn't matter what our trust says. The money is going to Mike. Tax inefficient beneficiary designations. Okay, so tax deferred accounts. There's better ways that we can potentially use those, especially if you have charity written into your plan. So if I inherit a retirement account from my parents, I'm going to have to pay the associated income tax, which Mike just mentioned how important income tax planning is in relation to the plan, not just the state tax planning. But if my father wanted to do a piece for his church, there's no better asset to give to the church with than tax deferred assets, because the church as a nonprofit is not going to have to pay income tax on those. Again, talking a little bit about the Secure Act that came through. Disabled beneficiaries are one of the classes that potentially still gets a lifetime worth of deferral on required minimum distributions. So does it make sense carving out our retirement asset for our beneficiary that has some sort of special needs? Asset protection for children and grandchildren. Mike kind of covered this on his slide with the diagram. A lot of times when we see these off-the-shelf plans, or quite frankly, plans that are 20 years old at this point, the default to grandchildren most of the time back then used to be 18, 21 years old. Well, as time's gone by, it seems that we want to bump that age out farther than we had in the past. So now, quite frankly, we're starting to see maybe we don't want to give outright access to the funds until they start hitting various ages. and I like doing it in steps. So if they make a mistake with the money at age 25, you know that there's 2/3 left, possibly to give them at 30 and 35. Asset titling, again, becomes very important, making sure that all the assets flow through the plan that we've created. Proper fiduciary appointments. Are the people that you've named in your documents still the people that you want to have manage the assets? Are they going to be an age that's appropriate? If you did your document 20 years ago, you might have named your parents into these fiduciary roles. Does that still make sense at this point? Drafting with proper flexibility, it's not really a mistake that we see, but it's certainly a way to make your documents better. LPOA stands for limited powers of appointment. Essentially, what that says is when money flows down into that yellow credit shelter box for a surviving spouse, or potentially the orange boxes that we looked at on the chart, so the kids' trusts, we might want them to be able to direct assets down to their children, okay, or maybe college. And we have the ability to do that with what's called a limited power of appointment, where we can shuttle money down to descendants of our children. Removal and replacement powers. I've seen plenty of documents that possibly named a corporate trustee to step in and manage the trust account for children. It tends to be common practice now that you give the beneficiary the right to remove and replace the corporate trustee as long as they put another corporate trustee in place. But I have seen documents that did not give the beneficiary that power. All of a sudden, then you're having to get the court involved if the trustee is not doing their job, something we just assume avoid. Trust protector powers. Trust protector is a pretty cool role. Relatively new in the lexicon of drafting. Essentially, trust protectors give us the ability to make a little bit more flexibility in documents that have become irrevocable. Okay, so the credit shelter trust for our spouse, or those irrevocable trusts that exist for our kids and grandkids. Quite frankly, we could do an entire session talking about trust protector powers, but it's a great way, a new kind of technique of drafting that gives us a bit more flexibility as it relates to what are now irrevocable trusts. And with that, Mike, I'm going to shoot it over to you to talk a little bit more about advanced medical directives.
Great, thanks, Andy. So, on those items too, what I would say, recent retirees, what you should be, what are some of the common things you'll see right away? Because there's a lot on that list. Certainly having trust protectors and adding flexibility now in these irrevocable trusts is something new, contemporary, and worthy of discussion. The thing that I see is often, the documents get old and the children were much younger and you weren't really thinking about grandchildren. So you might have a delay of distribution in documents for children when your children were teenagers. Now you're a recent retiree or about to approach retirement, and you find out the attorney, he had an outright distribution if a child would predecease for grandchildren. There wasn't a delay, for grandchildren for a predeceased child, as well as equivalent for children, because it really wasn't thought of at that point in time. It wasn't a circumstance that you would otherwise plan for. So that'd be an example of a situation where, again, good time to take a look at those documents and start to run through. The family's changed, everybody's older, and make sure the plan is up to date.
I also see families having numbers in for their children, and now all of a sudden their child has reached those ages, and they have a hesitation about the amount of money that's going to go out to them now that it's going to be an outright distribution for their kids.
Absolutely. Yep, exactly. Okay, so powers of attorney, just very short order here. There's some tricks to the trade. If certainly everybody should have a power of attorney for property and healthcare, naming somebody to make decisions for themselves. Two philosophies here kind of across the country when attorneys are drafting these documents. More and more of them are moving to the effective immediately approach. That is, how is the authority triggered within the document so that the agent can step in and start making decisions? One way is effective immediately. The other way is to require some type of certification. Sometimes it's a physician certification or two physicians certifying incapacity, and then the authority of the agent kicks in. It's hard to get those certifications if there's a long period of disability for years and years. Institutions and providers might want you to keep updating. Yeah, this person is, they were disabled in the beginning of 2022. They're still disabled, not able to make reasonable, responsible decisions in 2023. So, to avoid that, we often make the recommendation, just make them, if you trust your agents and their family, just make them effective immediately. You don't have that hurdle. They can immediately go up to hospital, start communicating and accessing medical records. On the POAs,
when clients say to me that they're nervous about this, I typically will say, well, maybe we should talk about naming some different powers of attorney if you're not comfortable with this person stepping in for you right now at this point.
Yeah, exactly. Or you can maintain those documents close, other than the one you're providing to a physician on the power of attorney for property. Then they don't have the authority there. Make sure you name, put the contact information down, cell phone numbers. I always like to make that recommendation in the POA healthcare. That way, when it's made a part of the medical records, the children or the agents, their contact information is there. Multiple layers of successive agents. This is just proper planning. I see situations, couples will name each other, and then they'll maybe just name one child. Put them all. The attorney isn't going to charge you anymore, and you just have more protection there. So as you get close to retirement, take a look at your POAs. Maybe the children were too young previously, and so you were naming siblings as agents, but now you would feel more comfortable. The children are a little bit older, so new POAs are appropriate, and you can just name the children directly. Make sure you've thought about this living will versus POA healthcare paradigm, and then make sure your physician has a copy of it. Let's move on, Andy. We'll make sure we have time. We're getting lots of great questions in the Q&A as well, so I want to be able to spend a decent amount of time there. But let's just touch just a little bit on charitable giving. This is a big deal for a lot of estate plans, leaving a legacy. Not only making sure that you take care of your family, your spouse through the beneficiary designations, the children. But I think, I found in estate planning, the ability to do something for a particular cause, something that's near and dear to your church or what have you, it really sends a message to the next generation. It's a value. It's the transmission of those values. This was important to me, and I want you to see it. It's really almost like a final lesson in life. Now that the estate plan, through death, that, this was important to me. Maybe it's 5% or 10% off the top, and might be a church or a particular cause or something in the community. Super important. Interestingly enough, I was looking at some statistics. The baby boom generation, they were about 23% of the population. They're defined there in the slide. They do about 43% of the giving year to year, which isn't surprising. They're in an age group where they can do the giving. But I think the philanthropy is a bit of a dying, phenomenon in some respects. Millennials make up about 25% of the population. They do only about 11% of the giving. And then the Generation X is about 20% of the population and do about 22% of the giving there. So there's an opportunity here. There's things that are important to you. There's the ability to transmit those values and generational beliefs. And so I would encourage everybody in the design of their estate plan, again, at retirement, this might be a place, newly retired, to sort of think about that. You didn't think about it before because you were focused on taking care of a spouse, if a spouse survived, young children, getting them educated, getting them to the point where they were able to get settled a little bit, down payment on a house, startup of a business. Now you're at a point in time, you've made it to retirement, you're quite a bit older, you can start thinking about philanthropy. And so it's a good time to pull this into the discussion. Andy, what are some of the ways, or let's talk about charitable planning just briefly from the perspective of some ideas here for the audience.
Yeah, sure. So there's several different ways to give a charity. Writing a check. So actually writing out that check during our lifetime to the church is very common, that people understand, and happens all the time. But when we're trying to think about how do we give, we always kind of want to keep in the back of our mind, what's the most tax efficient way that we can do this? Okay, we might as well get the benefit if we're going to give. So donating appreciated funds can do that. So let's say that we bought a stock or a mutual fund at $10. It's appreciated to a worth of $100. We have the ability to transfer in kind that gift. So we give them the stock or we give them the mutual fund instead of cashing it out, paying the capital gains tax, and then giving the gift. We have the ability to just transfer in kind the actual asset. Donor advised funds. I love using donor advised funds in my planning. We're going to talk a little bit more about that on the next slide. Donor advised funds are essentially like little mini foundations that we can create using a custodian. And then you have the ability to do qualified charitable distributions. Okay, so once we hit that age where we have to start making our RMDs, required minimum distributions from our retirement accounts, the IRS has a specific carve out where we can send that RMD to the charity and it doesn't hit our gross income, which could be really good now that standard deductions are quite a bit higher and families are finding themselves not itemizing as much anymore. So a little bit about donor advised funds. Like I said, a donor advised funds, it's a pretty cool vehicle for giving to charity. It is kind of essentially like your own little mini foundation. What we have the ability to do is we can give, money during our lifetime to a donor advised fund that we've set up with a custodian, Schwab being one that we use a lot. Okay, so it's an actual account that we have there. And we make that donation. We get the tax benefit when we put it into our donor advised fund account at Schwab or whatever custodian you're using. So you get the benefit from a tax standpoint immediately, but now it's held within that donor advised fund. And now we can direct when we want it to go out, how we want it to go out, what charity we want it to go to. It has a particular use if we're going to have a significant amount of income in 1 year. So we can get out a big chunk of it. Okay, so let's say we put 10 years worth of giving to our church within our donor advised fund in this year where we got a big bonus. Okay, now we have the ability over those 10 years to spread out those distributions, even though we got the full tax benefit in year one. One of the big reasons and ways that I like to use donor advised funds within my planning is if a client would like to have charity be part of their estate plan. A lot of times, instead of naming the actual individual charities within their trust, I like naming a donor advised fund. So now that we've named the donor advised fund, the money's going to go there. But if the client wants to update what charities they want their plan to eventually go to, okay, they have the ability to just change the beneficiaries right on the website. Okay, they can change what beneficiaries they want without having to update their plan. So it's a nice way as you continue to support different charities during your lifetime. You can continue to benefit them after your passing without having to go back and redo the plan. With that, Mike, I'm going to pass it over to you for some lifetime gift talk.
Sure. Thanks, Andy. So, this is the last topic we have, and I added this one. I should have looked it up beforehand. I think about the Mark Twain, when I was 14, it's something like this. I couldn't believe how little my father knew. And, when I was 19, I couldn't believe how much the man had learned in 5 years, and, or something along those lines. And when I think about estate planning, certainly we're focusing on the plan itself. As we talked about estate tax planning elements, make sure we're not incurring any necessary state or federal estate tax, the income tax, smart way to design the plan. And again, with the philanthropy side, maybe we're using taxable IRAs to fund the charitable piece so that we have maximized those distributions and a tax-free distribution to charity, not using other assets to go to charity. So there are a lot of elements here, but this one is, once we cover all those things, beyond the accounts, beyond the other consequences, the estate plan, and certainly when you're at that age of, about to retire, recently retired, you have all this wisdom, okay, and knowledge and life experience. And how do you, that should also and can be also a part of your estate plan. How do you provide that to your family? So it can be done with, gifts during lifetime. This was something that was meaningful to me. It belonged to my father. The transmission of a value proposition. Education is important. I'm setting up education trusts for your children, my grandchildren. Lots of ways to sort of impart this into the estate plan. There's a concept called ethical will making. You can Google that concept, and it's about, writing letters to family members. If you're reading this, something tragic happened to mom and I. And again, when you're at retirement, you've accumulated those assets. And if there's a situation where that plan is now in an administration period, there could be significant assets. How do you want those assets utilized? What are the values that you want to impart? And so you can do that through the estate plan as well. Again, very important as you get to that point in time to try to to impart, might be even some family heritage there as well. So I think of a chest that I have that I was given, from a grandmother who, came over, from Europe with all of her belongings in there, and that my children have that, and they have that symbol of entrepreneurship and, sort of the ability to start from scratch and move to a better place. And there's a value, there's a family heritage there, and it's important to inject that into the estate plan. And again, if you're at that point where you're redoing your estate plan, don't hesitate to supplement it. It's not just the accounts and the beneficiaries and the taxes. It's the other things that you can do as well. So okay, we've got saved. We succeeded and got through a good amount of time.
Always talk.
Yeah, we got about 9 minutes. So I see some favorite questions. You probably see some as well, Andy. Why don't you take a couple, and then I'll take a couple. We'll bounce back and forth here.
Yeah, so they want me to say that you have the option to schedule a complimentary 15-minute call with someone on the Savant team. We'd love to discuss your questions one-on-one to address your individual needs. So there's going to be a link in the chat that you guys can click into if you want to schedule that meeting if you don't get to your individual question. So now we're going to cover some of the questions that have been submitted throughout today's presentation. And clicking in, Mike, why don't you take the first one as I start looking at what other ones are out there?
Yeah, I've been studying them a little bit. So with respect to not naming a trust as the primary beneficiary, right out on accounts, again, that relates to the differences between a spousal rollover, which is going to be a longer deferral, not significant, as opposed to a single life table. So instead of getting the uniform table 1/25th, you're going to get maybe a 1/15th RMD distribution. Considering a 72 to 75-year-old, not a huge difference, but when you can, you'd like to pick up an extra 10 years of deferral if it meets the requirements of the estate plan. If you don't have a spouse, then you're probably in pretty good shape, depending on what that estate plan is, to just go straight to the trust, because that's where you're going to have all of the different contingencies, primary, secondary, grandkids, et cetera, built in there. But that would be the reason that you wouldn't just go straight to the trust. The other thing is the if the surviving spouse is named directly, they can do a rollover. They can defer until their retirement age if they're not already there. So 72 to 75, depending on where you are. Secure Act 2.0 or what have you with the new required beginning date, depending on your year of birth, the year you attain age 70 and a half. So there is that deferral period, then the longer deferral period in the RMDs from the account to consider, and then just flexibility for a surviving spouse. There's a question here, and we've talked, perhaps a little bit longer than we should with a situation where there's a spouse or children. So there's a question regarding planning, without kids, and what suggestions there. The thought that comes to mind for me is making sure that you think it through. Could it be nieces and nephews? What's that extended goal that you have, or could it be charity or charities? And if you're going to do that, I think too many people just name a charity and it's unrestricted, which means the charity can get it and use it and spend it in the year that and sometimes they think it's almost a goal for them to do that, to spend it right away. I tend to like endowed gifts, where it stays in and it supports a particular cause. 5 or 6% a year comes out forever, and that way it's an endowed gift. So if you're in that situation where you're not thinking maybe individuals, you're thinking more charity, the recommendation would be work harder on that, to spend a little bit more time. Learn about your community foundation in your community. Learn about your charity. Does your charitable objectives, do they have endowments as opposed to unrestricted gifts? And are there types of endowments that are attractive to you based on your goals? Maybe you make your own endowment. Maybe the charity or the university is willing to create a particular endowment, like a scholarship or something like that, a scholarship program. So I'll take
The
those
other
two
thing I would
questions.
just add to that, Mike, is if they're talking about who to name in the various roles that exist, so agency roles, executor role, trustee role, you certainly have the ability. You don't have to name family members into any of those positions. You have the ability to name friends if you wanted to. And if you didn't have a person that you can name in the roles, there are professional services that exist out there where you could name someone to step in to the role of trustee, to the role of executor, the role of your power of attorney for property. Those solutions do exist out there.
I see this question on moving to a different state. Do I have to redo my estate documents? It's, the starting point is always the powers of attorney. Most states will have a provision which says we respect a power of attorney that's been executed according to another state's formality. So it will carry from one state to another. But sometimes the hospitals, the providers aren't used to seeing an Illinois form in Florida, for example, or in Arizona. And there's simple fill in the blank forms. So we often recommend you consider doing them in a new state. If you're trying to make sure you establish domicile to get out of an estate tax regime, you'll want to, there's certain things that you need to do to establish domicile. One of the things that can help is actually going to see an attorney and having documents there. The underlying estate plan, it's a good thing to check. Again, this is something, not saying that it's not transient from one state to another, but like the example that I gave, where you're trying to preserve community property and get this double step up in basis in a non-community property state in the South. There are little nuances. Yeah. I think it's a super good idea to spend, just a little bit of time, go see someone. Again, this comes from a practitioner. It's like a tune up of your furnace every year. Do you need that furnace tuned up? Up here in the north, we tend to do that, or your air conditioner in the summer. You may not. You may be able to skip a few years. I think it's a good idea to spend just a little bit of time with an attorney or solid counsel to make sure that this is all done correctly. So not always.
It is. Yeah, I was going to say it's for sure something like you should at least go get it looked at. Because let's say that you're in a state that has state level estate tax, your plan might be built and constructed around avoiding that I'm going to say Illinois because that's where we're sitting today, Illinois estate tax. All of a sudden you move to a state that does not have state level estate tax anymore. And your plan could actually be detrimental to you income tax wise because it was designed to try to minimize the potential state estate tax. Okay, so there could be updates that you want to do just for tax reasons at the new state that you're moving into.
And somebody had a question: why would to defer taxes if you're deferring it to a point where there might be a higher tax rate later on? That's a good point. You might want to. There are times where we want to actually, if we don't generally want to pay tax before we need to. The estate tax would be an example, but there may be cases where we say, we're pretty sure there's going to be a higher tax later. Let's take the hit now. May a donor advised fund be used to transfer assets to family members through charitable giving? No. On the DAFs as well, I would say make sure you pay attention to that you've named successor charities at death, or that you have successive individuals that can decide where those assets go. And then you could use a testamentary charitable lead trust, however, which would operate to leave a certain percent to charity for a period of time and a remainder to family members. So that might be something worth Googling. I think we're pretty much out of time here, Andy. Lots of good questions. Yeah. We can take some of these and respond to you privately. Great opportunity. If you're recently retired or about to retire, take a look at your estate plan. This is a great time to do it. It's super important to do. It's a gift to your family, and scrub through it. Any final comments, Andy, you have before we close out?
No, I just want to say thank you to everyone for participating in today's webinar. If at any time you are looking for more information about Savant and what we do, I invite you to go to savantwealth.com to learn more. Thanks again and have a great day.